Hello, loveys. Happy Sunday. And it is November 3rd, 2024. And how would this week be best topped off from the roller coaster ride we have all been on, but to have our best friend from out of town, the most incredible legal mind that I have the pleasure of knowing, and we all have had the pleasure to get to know over the last probably year, our friend, Mr. Mark Bederow, who has generously watched the Patriots and then said, Kim, let's go. So without further ado, are we ready to better call Bederow?
Hello.
There he is.
How are you?
I'm good, Mark. How are you today?
Okay.
You're doing well. I love your hoodie.
Ah, yes, the Salute to Service Patriots hoodie. Yes.
It's very nice. Is it a limited edition?
It's an annual thing they do. You know, they support the military. Every NFL team does it. So it's just a camouflage Patriots thing. It's the best thing they have going for them right now.
Oh, my God. Listen, we're in rebuilding and we just have to get, right with it for a while. But let's get everybody in and say hello to you. Jen O is just obsessed. Oh, someone said, LML Bunny said the Pats almost had it. Did they?
Well, they tied the game on the last play of regulation. Should have gone for 2 under the circumstances, but lost in overtime. But they're a terrible team on the road. They should have gone for 2 right then, win it right there. Would have liked to have seen it. If they were a better team, I would have said no, but I think they should have.
Oh, absolutely. Always go for it if
nothing to lose. Nothing to lose. And get the quarterback even more experience under pressure. But whatever. They'll, another step closer to a top draft pick. So it's actually not a bad thing that they lost.
Right. Absolutely. What do you think of, sorry, we'll get into, what we're here for, but I was wondering thoughts on Tom Brady as a commentator.
Getting better.
Yeah.
Rough start, but brilliant football mind. Kind of has a nasally voice a little bit. So maybe doesn't have the best TV voice, but he's also Tom Brady. So, what could I ever say bad about Tom Brady? Nasally voice is probably the worst I could say.
Yeah, he might get a little bit more nasally now that Giselle is pregnant with another child. He might be.
Something tells me he'll be okay. I don't think he'll be okay.
I agree. Absolutely. So, Mr. Bederow, you have been very MIA for us. And when this week, just because of work and you're very busy, but it has been quite a week and there is always things that come up, but I wanted to ask you, did you have an opportunity to read the 2-part Vanity Fair article on Karen Read?
I did.
I thought it was incredible. Can you give me your thoughts on it?
It was very thorough, very good. What you'd expect from a magazine with the credibility like Vanity Fair. It was good journalism. There were some interesting nuggets in there. Obviously, I thought it was much more favorable for Karen Read than some of the other recent attempts at cooperating with other media outlets. And I thought there were some just really interesting little nuggets that perhaps nobody really knew, even though you kind of thought, such as something I mentioned actually right away the morning I read it, and then others picked up on this, was the idea that nobody in the DA's office, according to some source or sources, was willing to take this, and that was the reason for bringing in a ringer to try the case. It was really unclear prior to last week whether it was, would nobody be willing to do it? What was the reason why they were bringing this guy in? And it's just the worst case scenario for a DA's office when you can't get a public servant to prosecute a case to the point where you have to expend public resources to literally bring in a ringer to try a case. apparently against the advice of everyone else in the DA's office. I mean, again, coming from a DA's office background, certainly a much larger office than the Norfolk DA's office, frankly, a much
Oh,
more,
yeah.
much more advanced office. But nevertheless, normally what would happen in a large office like the one where I came from, there would be a so-called blue ribbon panel to discuss these kinds of large cases, very experienced ADAs with the DA, the other executives, and they would kick it around back and forth and make a recommendation. And it's almost unheard of for the DA to literally just not follow the advice of everyone else in the office and say, well, you're all telling me I shouldn't prosecute this case, but I am going to prosecute it. And the only way to do it, I guess, is to go outside the office. It's unheard of, unless, of course, there's a conflict of interest, which there's not, because they're still working together. So I thought, of all the things that were in the Vanity Fair article, that might be lawyer inside baseball. Maybe the public isn't as interested in that component of what was reported, but I found that to be far and away the most interesting point, that the office is telling the elected official, you shouldn't be doing this. And he's just full steam ahead, down with the ship, and ready to go and use tax money to bring in someone else to do it. And it just strikes me as what I already thought was crazy, even crazier.
Yeah, and I actually saw yesterday there was a attorney, one of our attorneys from Massachusetts. His name is Andrew Meyer. He had sent actually a letter to DA Morrissey, asking for comment on this, because when he had called Norfolk DA's office, he was directed to the press secretary after reading what you are exactly saying, with them saying that the top prosecutors refused to take this case on. He ends up calling and they say, please refer to the September 16th letter. Well, the September 16th letter from Norfolk DA's office it only included the appointment of Hank Brennan. There was no reason in that letter. So, that's just wild to me. And then again, after he had sent this email and this fax over to DA Morrissey's office, there has been no answer. And he believes that is a very insider, but a big deal if no one else would take it.
It is a big deal. It suggests it's an office in chaos, an office in disarray, an office that has no confidence in the so-called leader of the office. And it also exemplifies the failure of the mainstream media. I mean, with all due respect to whoever the lawyer is doing the podcast, asking the right questions, where the hell has the Boston Globe, the Boston Herald, NBC 10, Channel 25, all these other people, they all reported on this Brennan coming in, and they made a lot of noise. Oh, it's Whitey Bulger's lawyer, which to me, whatever. I don't fault lawyers for representing clients. That to me, and most real lawyers, you kind of roll your eyes at that. But none of them asked the real question or the lead. And the lead should have been, you have a DA's office of experienced lawyers. You have a series of homicide prosecutors. You are paid by the public. You work for the public. You were elected by the public. Why is your office, after one trial, apparently incapable of handling the exact task to which you are assigned and to which you take public dollars to do? And why are you expending other resources to bring in a ringer? And that's not a disparaging comment to the lawyer who takes the case for whatever reason he chose to take it, but he's a ringer. They brought in somebody that Morrissey, we all were led to believe, thought was better. And maybe he is better. But the new fact to add to this is that it was almost like a mutiny. There's nobody willing to do it. And yet the DA said, I'm going to do it anyway.
Yes.
So the real story here is, what the hell is going on inside that office? We know the chief ADA quit, right? We know the PR.
Yes.
We know the PR person quit. All this is happening around the same time period. So where are the members of the mainstream media, the local media, or even the national media to ask the obvious questions. And to this day, no one has asked them that I'm aware of, other than, what you just described. Not that you'd expect Morrissey to answer, but there ought to be pointed questions. It ought to be on film, and it ought to be reported in the news. And if he refuses to answer, I'm not sure that's an acceptable answer, because you are expending extra public resources when your office has public resources. And if the public can't trust the elected official, then, why is this person the elected official? And I think the other disappointing component of this is, where the hell are the candidates that are running for DA on this? They've been shockingly silent. I mean, this was a fastball right down the middle of the plate at 92 miles an hour, with the pitcher telling the hitter, here it comes. And they don't seem to have pounced on this, because that's the kind of thing that somebody who wants to grab the office away from somebody that a lot of the public believes is a corrupt operation ought to be asking the questions, and they're not being asked. Instead, the story is, well, he was Whitey Bulger's lawyer. Okay, that's interesting, but that's not the story here.
No, not at all. And additionally, with that being said, I had a question about something that I learned that I did not know from the Vanity Fair article regarding them having access to Karen Read's family's financials. And that, to me, I just want to know, Mark, how is that even like within bounds? That feels so out of judicial prudence, and like them, like that's throwing such a wide net, in my opinion, to think that Mr. Read, Mrs. Read, her brother, like not just her information, her family's financial records, seems like a gross misconduct in my, as an outsider and somebody just from the public.
So,
can you tell me why?
Yeah. I mean, obviously, and again, coming from that background, if you think there's a good faith basis for relevant evidence, you pursue it. And as long as you can convince a judge who ultimately determines whether a subpoena is in good faith or not, you go with it. And without getting too close to a related case to Karen Read, but some of this is in the public record, they were on a wild goose chase, as has been reported, that they believed that the Reads bought another person a vehicle. I mean, that's been reported out there. And they got that information. And although these are the same people who, don't knock on the door of a house where a crime may have occurred, don't look for ring video, don't do any number of things that you would expect, reasonable prosecutors and police officers to deal with, when they were whispered in their ear that, maybe she bought someone a vehicle, they went off the walls and started subpoenaing everyone and everything to try to, chase their tails, looking for proof about a vehicle, which of course turned out to be nothing. But I mean, in terms of were they allowed to do it? Maybe. Really, to me, it's a prioritization of resources and just, using your head on what are you trying to do? Are you trying to go after people for reporting on things, or, they just are so obsessed with getting Karen Read for something like related to that, rather than trying to solve, whether a crime occurred or not back in January of 2022, when at that time they should have been perhaps a little more agnostic about who did it and just follow the evidence. The problem now is everything is geared towards Read, and the tunnel vision, the blinders are on, when, good police work, certainly in the beginning of an investigation, should be agnostic. I mean, you just follow the evidence, and wherever it goes, you go. And if it turns out to be really unpleasant and uncomfortable, it is what it is. But obviously, if you're interested in solving what happened to, a deceased police officer lying on someone's lawn, for example, you go where it takes you. And they didn't do that. But when it came time to see if Karen Read or her family were in the business of buying vehicles for people, yeah, they rolled up their sleeves, got their elbows dirty, and got all in there.
We're willing to go there, almost in a salacious undertone with it. Absolutely. Sure. And going there too, Mark, I have noticed for me this week, after the Vanity Fair article came out, I felt, as you said, to know that Julie Miller, a pregnant at the time, 6-month pregnant journalist, okay, stayed in a home with Karen for 3 days. She had a backup plan because, of course, you don't know how it's going to go with, even personalities and things like that. But I think for women specifically, looking at that and knowing how protective you are of your body, yourself during pregnancy, that just speaks to the character of Karen. It speaks to the character of Julie, and to how that she was able to, in that such short time frame, get to see the good, the bad, the everything about her, unfettered access to a client without attorneys present. This, in my mind, is unprecedented access to a defendant who is going to be coming up for retrial in January of 2025. Thoughts on, just that in and of itself? Does this scream to you just another check in the column for all the defense team is absolutely certain of Karen's innocence?
Well, they must be, because look, let's just call it what it is. The idea of lawyers giving a client who's going to be retried for murder to spend essentially 72 hours or whatever it was, just completely without a net, without lawyers, without screening, whatever, with a reporter from Vanity Fair. And of course, Vanity Fair in the print media, in the magazine genre, that's the gold standard. That's like 60 Minutes for TV news, that kind of thing. To grant her that kind of access, I've never heard of anything like that.
Right.
Honestly, to me, it's crazy. But, it is what it is. I don't know the thought process that went into that, other than the degree of confidence that they must have in her is absolute. But even then, lawyers are usually programmed to believe something could go wrong, something could be misinterpreted. I just want to know. And for them to do that is unprecedented. In an open case like this, I've never seen anything like that.
Yeah, I just thought that it spoke volumes, without saying anything, right? And additionally, kind of bombshell news for anyone who has closely followed the case was that Karen is in possession of carpeting from 34 Fairview upon the new owners purchasing the home and doing renovations. Unfortunately, as has been reported, this could cost $5,000 per one swab, okay? And, if you don't know where, on what carpet, what room anything came from, that is a needle in a haystack, right? So these are just, and she's also keeping it in a storage facility that is climate controlled. And when that was kind of given to us, I thought to myself this, ain't that some shit that Karen Read has put carpeting from 34 Fairview in a climate controlled environment, when we know that the evidence in this case from Officer John O'Keefe, who tragically lost his life on the lawn of 34 Fairview, his evidence was laid out in PD to dry out initially, right? In temporary storage, then went to Mass State Police for their crime labs. But it just kind of shows a juxtaposition of somebody who is 100% keeping all of her viable options and taking things so seriously, meticulously in the management of evidence that she's been able to gather, when our own Commonwealth and Mass State Police did not afford her or Officer John O'Keefe that opportunity.
So the carpet thing is fascinating and shocking at the same time,
Mm.
but I have kind of a different view about it.
Tell me.
I don't know why it's not in the possession of the federal government. And I don't know why they're not testing it if all this other stuff is going on. So that's not meant to be a buzzkill or anything, but certainly if the cost is prohibitive, and in theory, if there's any biological material, blood, DNA from John O'Keefe in portions of that carpet, and they can match it to the right room, then given what the FBI, U.S. attorney really, is theoretically investigating, that seems to me to be the kind of thing that they ought to take over and do. Not just the cost, because the cost is, any of that, but I don't know why a private citizen would be paying the freight for holding it and testing it if there is some kind of federal investigation going on. So I don't really know what to make of the
Of
carpet.
it.
People are commenting about chain of custody and whatnot. That's not the reason. If they grab the carpet right out of the carpet guy's truck, is that a perfect chain of custody? No. But if there are witnesses to establish, how long they had it, where it came from, and if they find, John O'Keefe's blood and DNA in some blotch all over it, then I think most sensible people would say that given that, he had never really been in that house previously, that's a serious problem for the prosecution. So it's not really a chain of custody thing. And also, you would still test it. You want the answers. And the other thing that people need to realize about chain of custody, because this comes up a lot during all these discussions about, why it's admissible or not inadmissible. Chain of custody doesn't go to the admissibility of evidence. It goes to the weight of the evidence. So it's not the kind of thing that literally will have a judge rule evidence inadmissible. It is the kind of thing that is allowed to be argued to a jury as to why it's not reliable. And then the fact finder, which would be the jury, would determine what, if any, there I said it, what if any weight to assign to the evidence's value. But, the other thing is this, that interview with Karen is a couple of months old. It's, so I don't know if they turned it over to the feds. They didn't. Could it be that they got it, secured it, and it was taken a week later? I don't know. But certainly if there is some kind of federal investigation into what's going on, that is something that the federal government, I would think, would be taking the freight on, not having a private litigant test it. That doesn't make any sense to me at all, actually.
Absolutely. Well, that was just one of kind of the major themes. So thank you so much for that. And as always, for giving us the actual skinny on what is needed and what would be needed. Now, there was kind of a comment in the article from when it was between David Yannetti and Karen. And I want to make sure that I read it correctly. Okay. It was discussing when, it basically said that Karen was offered a potential, a plea for a couple of years. And she said, no dice. I'm not taking a couple of years. I would rather go to jail for a crime that I didn't commit than give them that win, basically, because I didn't do this. 10 toes down, Karen Read standing on business. Now, if there was, I don't know this, but if there was a plea deal that was given, right, that was for 2 years on a manslaughter, isn't that for all of us in the public, just an absolute another check in that column, Mark, of absolutely not guilty?
So,
because you would want to take that versus not have to go through all this bullshit.
So when you do this for a living and you play the game with negotiating and assessing, you just play the game. Somebody's indicted for an intentional murder. there are certain situations where a prosecutor will attempt to negotiate down. But if the theory is that you mowed down a loved police officer, in the manner that they accuse of her doing, just literally mow him down, leaving the scene of an accident. It's all intentional. You quote unquote falsely accuse all these innocent people of things. If that prosecutor who is theorizing the case in that way is offering 2 years in prison, what they're telling you is, from the defense side, they know their case sucks. Okay. Because this is not a 2-year case. If you believe what they claim to believe and what they've tried, then she deserves decades in state prison, if that's what you believe.
Life, yeah, that would be her sentence for the second degree.
So this is the kind of case that they ought to make an offer, but it's also the kind of case that it doesn't shock me in the least bit that the defense never gave any serious thought to taking a plea. And of course, you have to avoid Twitter reporters, Twitter lawyers, Twitter towels, all these people who tell you, oh, she's going to take a deal or she agreed to do this. If you look at the way Karen Read's personality is, if you look at the way the case is, which is full of holes, I'm sorry, it is what it is. Whether you think she did it or not, there's reasonable doubt everywhere. If you look at the caliber of lawyer that she has, you look at the claims that they've made, you look at the fact that they brought in 2 lawyers from California at extraordinary expense to try the case. They're not here to plead guilty. Some cases simply need to be either dismissed or tried, and this is one of them. So it doesn't shock me in the least bit that they would make an offer. Me personally, it doesn't shock me that they would literally, what lawyers call, try to give the courthouse away on a murder case because the case stinks and they know it. And everyone in the Norfolk DA's office knows it too, because they're not willing to prosecute it the second time. And it shouldn't shock anyone that the defense position is, we're not going to take it. So all of that makes perfect sense. And it doesn't surprise me in the least that, her comments to Vanity Fair would be, if you want to martyr me for the cause, then so be it. I'll do it because I'm not guilty. And she's not made of the kind of stuff, at least based on what I've seen in the conversations that I've had with her, to just, say I did something I didn't do to make everybody feel better. So, none of that surprises me in the least.
And another thing, when you're saying about like the stock that she's made from, I wanted to say that like when I did my reviews of the Vanity Fair, I did like part 1 and part 2 of it. And for me reading part 2, Mark, it was like my whole life. And for many women, it's like I bend and bend and bend till I break for everybody, right? Women, moms, my profession, everything. It's just, always put yourself last. And we're kind of, it's conditioned almost in us. And like seeing her stand up and stand so tall and so, just with no recourse or trying to make it nice, right? Like sugar and spice and everything nice. And that's what girls are made of. She is not going to cower. She is not going to continue to make herself smaller so that she is palatable, right? For some people, I don't like her personality, or I don't like that she is smiling, as was said, the happiest murder defendant in America. Well, to me, that is admirable that Karen is saying, I am 100% not going to allow you people to shove this down my throat or to send me down the river without me fighting with every ounce I have back.
Her position is that I'm innocent. I'm not guilty.
Yes.
I didn't do it, and I'm going to fight you to the death on that.
Yes.
And the reality is, her position is, I'm not going to bow down because the lords of Twitter demand that I be miserable and go stand in the corner staring at the wall with my head looking down, rocking back and forth, and trying to profess for the sins that she says I didn't do. So
Right.
if you can't accept that, that's kind of a them problem, not a her problem. Obviously it's 2.5 years, almost 3 years later. It was her boyfriend, whether people want to believe that she's grieving or not, whatever, that's really not anything to
Yeah.
me. But the fact of the matter is, she's saying I didn't do it. I think there's a lot of reason to accept that view, frankly. But
Yes.
what is she supposed to do? One view is stay at home all day, stare at the floor, cry, and starve myself and contemplate what Michael Proctor wanted her to do, right? Kill
Right.
herself. Another way is to say, the hell with all of you. I didn't do this. You're smearing me. You're humiliating me, and I'm going to win. And fuck all of you. Pardon my French.
Yes.
And that's not really her place to really care how the lords of Twitter believe that she ought to behave or not behave. And as far as the O'Keefe family, they're entitled to their view of her
Yes.
or not. But she's fighting for her life, and they may very well be trying to incarcerate somebody who's not guilty and trying her twice for the same crime. So what do you expect her to do? I don't. And this is the kind of thing I think you saw on the Dateline thing too, where when they were interviewing Alan, we said, I don't really care what people think. She didn't do it. It is what it is. We don't have, this is what we're going to do, and get over it. And listen, that's how criminal trials work. And having seen this 1,000 times, I don't know what it is about this case, but
Yes.
for some reason, the behavior surrounding it is just so grotesque. And I guess it just comes down really to a bunch of lowlifes on Twitter. I don't know what else it is that just kind of gin this up into a battle amongst sides on Twitter, where it's like a tug of war over who has the right to declare, what justice for John O'Keefe entails. I mean, justice for him entails is the truth, whatever that may be. But these people who think she's the devil don't have a monopoly on the concept if she's innocent or not guilty. And if she's innocent, then justice for him does not mean warehousing her in prison for the rest of her life to make you all feel better. So it's really not about their feelings, even though they ought to be treated with respect and they're entitled to grieve and all of that. But at the end of the day, Karen Read doesn't owe them shit.
Yeah. Yeah. And, I thought that it was incredible, though, in the article too, Mark, where she says, if I did this, I would pay the price for this. Like, because there's been kind of with how I've seen the narrative based from the 2020 and from Dateline, it's that Karen needs to accept a responsibility. Karen Read needs to take accountability. And I thought it was incredibly poignant for her to say, if I did this, I would have taken accountability, but I didn't. So I'm not going to. And you're not basically going to Irish Catholic guilt me into making me feel as though I'm going to need to take accountability for a crime I didn't commit. And I'm in the public. Yeah.
This is why those episodes were so poorly put together and edited. Obviously, anytime you put together those shows, you're going to have family or the closest people you can get, as it were. But having them come on and say she needs to own up to what she did, that's a logical view for those people to feel. But if you're running a neutral production and you're a TV producer or editor, that adds nothing. Okay. Having somebody aligned with the victim's family say, I know she's guilty just because I know, and this is all unfair because she won't admit it, and she ought to admit it and tell the truth. That is useless television. I mean, that literally adds nothing. What they ought to do, if you're going to go through this exercise, is say to these people, why do you believe that? Like, or are you open to this? How do you explain this? Do you have an opinion on that? Have you ever tried to get answers from the FBI? Have you ever called the U.S. attorney and said, do you have evidence about Google searches? Have you ever asked Jennifer McCabe why you told 10 different stories about this? Have you ever approached Michael Proctor, this, that, the other? But instead, they just put people up to say, this is ridiculous. She's guilty, and, she ought to take responsibility, and we know she did it, and that's our answer, and we're sticking to it. That is useless television. It adds nothing.
Right.
They're entitled to that view,
Mm-hmm.
but that's not a rational one. That's an emotional one.
Right.
And court cases are not decided on emotion. They're decided on evidence and burdens of proof.
Amen. Say that louder for the people in the back, that it is decided on evidence and burdens of proof that come from where? The prosecution, not from Karen Read or our defense side. There is, those need to be met by the Commonwealth. And in my opinion, they have not done any of it.
We are dealing with such lunacy and just embarrassment over all of this, that there are people online who are literally, in talking about Vanity Fair and the research that they produced, that they sourced about why they believe, an internet search occurred at a certain time, which of course is not favorable to the prosecution. And there's evidence discussing whether the state police may be lying, that there are, people on the internet saying, oh my God, Vanity Fair is going to get, they're going to catch a defamation suit like the rest of us, because their opinion is that doesn't match what they are. These are the people that are trumping up, all these others who are trying to support this case on Twitter. And this is absolutely bonkers. I mean, it has become the kind of thing where, I'm not used to this. All of this that I've stepped into in some ways is so comical and so absurd that the people who are trumping up, attacking people for having different views are basically, people sitting on a couch, somewhere in the Midwest or, in Southern Massachusetts, doing internet searches, giving free legal advice, and just saying what the way things are. And that's just not how court cases are decided. So it's just become comical on some level.
Yeah, it's almost comical because like you said, Mark, now, like, I hadn't gotten a Twitter until the Karen Read case. So I don't know Twitter before this, but it is the wild, wild west. Okay. And every day, doesn't matter what I post on or what case I post on, it is brought back to, like, how I am a fool, a bad mother, a bad nurse. And also, why did you go to dinner with Turtle Boy? And your children would be disgusted with you. And I'm like, oh Lord, like, very angry humans. But when we go back to the 227 search, I want to tell you that I was they almost got me, Mark, because they had said that there was two, we know Jessica Hyde, and we had, oh gosh, I can't recall who's the other guy.
Ian Whiffen, I think is it.
Ian Whiffen. And then we have Richard Green on the defense side. And it was, for me, they said, this has been debunked. It never happened, blah, blah, blah. And I was like, it hasn't been debunked. It was differing opinions. And when you have differing opinions, at best, they cancel each other out. It has nothing to do with whatever.
This was another thing, the morning of the Vanity Fair thing, I just felt compelled to discuss is, again, the lords of Twitter and the people with the Twitter law degrees don't understand that when a prosecution has a burden of proof, and let's just say a highly contested point is the time of the search that you're talking about, I think all would agree, even these people who have, really a distorted view of how a court case works, I think even they would concede that if Jennifer McCabe searched Google at 2:27 a.m., if that's true, or more to the point from a lawyerly standpoint, if that's reasonably possible, okay, that happened, that you would agree that there's no good explanation for that. That is a very incriminating fact as it relates to her and some form of cover up and all of that. So if there is, as you just said, testimony on both sides where they have an expert or two who says, well, it couldn't have happened, or I don't think it happened, and the defense has an expert who says, well, I think it happened at 227, the DA is never going to win the trial unless they literally obliterate the reasonable possibility that it occurred at 227. Because if it's reasonably possible that it happened at 227 and you get jurors who will follow the instructions on what reasonable doubt is, if anyone in the jury room says, well, she might have sent that search at 227, that by definition is going to lead to reasonable doubt to believe that Karen Read is guilty for the reasons we just talked about. That, why would Jennifer McCabe do that? If she knew this, what else did she know? That sort of thing. So they have to wipe that evidence out. That's the whole purpose of a burden of proof. And the lords of Twitter and all these other, Twitter lawyers, they're always talking about she's guilty, she did it. But that's really not the issue. If you want to argue in your own mind, oh, I think she did it, that's fine. But when you state it with such certainty and she's going to get convicted, then what you really need to do is address how you eliminate reasonable doubt. Okay. So how do you eliminate that search completely? How do you eliminate the ARCA search completely? How do you eliminate the Proctor stuff completely? How do you eliminate the pieces of glass that were recovered, our taillight over the course of a couple of weeks, the inverted video? You could go on and on. There is reasonable doubt all over the place. It's suffocating, basically. And, a jury would be instructed, it's, Your Honor, what if we believe really strongly that she probably did it? If they sent a note to a judge and said, we think really strongly that she probably did it, is that enough? The answer from a judge would be, no, that's not guilty. That's not proof beyond a reasonable doubt. And in Massachusetts, they also have those ugly little words after it, to a moral certainty.
Yeah.
That in the other 49 states that I'm aware of, they don't really use that language anymore. It's very antiquated. I mean, that's really saying that we are steadfastly convinced, almost to a certainty, that she did it. That's never going to happen because of all of these. And they're going to argue, look, they're going to sum up at a second trial if it really happens. I think by mentioning all these facts and saying why that's reasonable doubt, the next fact, why that's reasonable doubt, and then, of course, marshal it all together and say, how could all of this together not be reasonable doubt? I think if they do a summation that way, it's a pretty fast acquittal.
Yeah, absolutely. I totally agree. And I just wanted to give the credit to that, who the expert was who deciphered from Vanity Fair as an independent, research or to look at all the evidence, was Umit Karabaziak, a PhD at Purdue in the Department of Computer and Information Technology, who specializes in iPhone artifacts and the limitations of digital forensics, to evaluate the prosecution's expert testimony, as well as the affidavit from Read's expert. And he said, based on my research and expertise, I concur with what I see in the affidavit from Richard Green. Okay.
The thing is this, I'm sorry, I'm going to cut you off.
Yeah, no.
You never look at any evidence in isolation. You have to put it together, what lawyers call marshaling it with other facts. And if you look at the general timeline of what's going on around the time of 2:27 a.m., it fits like a glove. I mean, these are the butt dials, other deletions, then there's all this weird activity going on at that same time. Could it be coincidence? It could be. But again, if you're the party with the burden of proof, which in this case is the prosecution, and you're the one that's speculating, you lose. So if as the prosecutor, if you're saying, well, it could have been this or it could have been that, you lose. You need to lock down. It didn't happen. It had to be. And I also think that, at a second trial, I mean, if it were me, I would certainly call the female state police trooper who filed a report about, Jennifer McCabe talking about the Google search in the process of praying, literally holding hands and praying in the back of her vehicle. And one of the beautiful things about the Google search, if you believe the DA, Commonwealth, whatever you want to call it, theory, is that's a finite time. It has to be at 6:20, whatever. I forget off the top of my head.
23 and 24, I believe.
Whatever it is. It's not rocket science. So you know what you do? You find that trooper. You find her, vehicle dashboard camera. You put it on at that time and say, is she even in the car? And if so, what the hell are they doing in the car? And if it doesn't match, then guess what? She's full of shit. Hard stuff. That's it. It's not hard.
Yeah, I think absolutely, right? Like there it is. And we've got Karen did mention about like kind of the first trial was on a shoestring, right? Budget that she was trying to, get through it as best as she could. And now they, plans changed. We know that the Commonwealth has, in what feels like such an interesting turn of events, not only hired the ringer in Hank Brennan, but now they're doing the additional chip off for, technology where they think they're going to get this additional information. You've hired now all new experts because that Trooper Paul can't get up and do reconstruction. What does that say of the overall validity and the strength of that case in the first place?
Look, the case is weak, and that triggers people. It's always been flawed. It's always been ill-conceived. I mean, I said that within 30 minutes of looking at documents from the case, what feels like a year ago, without even knowing who the people were or having any relationships with anyone, just calling balls and strikes as an experienced criminal lawyer in this case.
Yes.
It's not going to get any better. The problem is it's going to get worse because you can bring in a new expert. That's fine. The cross-examination of him is going to be, you ever heard of this guy, Trooper Paul? And are you familiar with his work? And have you read his report? Are you aware that da-da-da-da-da? And do you agree with that? And he's going to say, no, I don't agree with that. And I mean, you could go on. And they're going to do that with Proctor as well. They're going to do it with, all these other people. This doesn't get better. I don't know why some people online have said, well, a retrial favors the prosecution. The only people who say that, again, have law degrees from Twitter, okay? The defense is going to have transcripts of every single witness. They know what every prosecution witness has said. They know what things they can try to do differently.
Yeah.
The prosecution can't really do things differently, but they're going to have to because they can't use Proctor. They can't use, Paul. Other things that they've argued don't make a hell of a lot of sense. So giving the defense an opportunity to do this again and put more on the table, it's not going to get better. And the fact that the prosecution has a better lawyer, I mean, that's good for the DA, obviously. It's also good for the defense. It's going to balance the field a little more. When you have really experienced defense attorneys like she does, who are skilled at this and have done this many times, the trial is going to have more cadence. It's going to have more flow. The tennis volleys are going to go longer, and there's just going to be more fluidity to this whole process. And that's good for real defense attorneys, as opposed to the first trial, which you just wanted to poke your eyeballs out for half the time. I mean, I fell asleep in the courtroom almost. Almost literally fell asleep. It was that bad. That's not going to happen this time, but that's not bad for the defense. I mean, the evidence isn't going to get better. I don't know why they think it's going to get better. Now, if they test the car box and somehow, oh, look at this, we now claim we found all this thing, is that going to prove that she apparently in front of the house mowed down John O'Keefe, and yet there's no ring camera that across the street that didn't get picked up? Anybody who has a ring camera knows that's impossible. Okay.
Yeah.
I get birds chirping in my yard 50 yards away that trigger my ring camera. Okay.
Right.
A bug can trigger the camera from time to time. No one in the house heard it. I mean, flying back you could go on and on. It's not going to change anything. It's just not, she's not going to get convicted.
Yeah, I truly feel that, I truly believe that as well, Mark. And I just wanted to read this because I found this to be incredibly powerful at the end. It was how Karen wrapped it up, and it said, Read feels a momentum towards justice. It's starting one domino after another. She tells me, I just don't know how long the trail of dominoes is. Are there 10? Are there 100 more? I don't know how long it takes to get there, but I know there's a big explosion at the end. Boom.
Yeah.
And I was like, mic drop, babe.
Well, I mean, look at what happened since the first trial ended. By all accounts, 5 jurors at least, but speaking for 12, essentially, have said, actually, we acquitted on 2 of these charges. Okay. There's reason to believe that the jury kind of was uninformed about where the ARCA people came from, which is a little bizarre to me, but nevertheless, they didn't know. Proctor is on professional life support at this point. He is, cancer as a witness. I mean, he's just useless to them. Buchanan, when he testifies, he didn't get the biggest punishment in the world, but he's been sanctioned for his conduct in this case that relates to Michael Proctor. That's not good. And he's going to have to answer for the inverted video. And this time they're going to be prepared. Remember, this came out of left field and they just kind of had to do this on the fly. Tully has essentially been neutered since the first trial, right? Guarino, to our knowledge, hasn't been punished yet. We don't even know if he's under investigation. But I think most sensible people at this point recognize that his cell phone extraction skills perhaps are lacking in certain areas as it relates to other cases and even federal cases, as it were now. Trooper Paul is, going to have to go bye-bye.
Yeah.
So how is this getting better for them?
I don't see it. And even with, like you're saying, with an entirely new team, we can't make new theories from the Commonwealth. You prosecuted this case based on what you had round 1. Okay. Therefore, ergo, what do you think you're going to be able to? You can't pull rabbits out of hats when you are a prosecution in a DA's office who've already put this through the wash. You did a spin cycle on this. You didn't get the desired outcome that you wanted. And now you're thinking, if I change all of the equipment, in the washer machine, we're going to get a different outcome.
But that's because the people who think this is going better have law degrees from Twitter. They don't understand how this works. The prosecution is bound by the indictment. You can't just make shit up out of left field. I mean, you can kind of, within the same restrictions of a theory of the case, move evidence around a little bit. But when you do that, you're going to get called out on that by the other side. And of course, the other side's theory already is that you people are corrupt and framing her. And now you're trying again by, calling different witnesses with different theories. In other words, what it looks like is you're just taking mud, throwing it at the wall, and hoping something sticks. The other thing is everyone is going to know that she was acquitted on 2 of the 3 counts anyway. And I don't care what the ruling is in several weeks that comes from the high court in the state. Everybody knows. It's like big news. And and the dumbest thing the prosecution could do is try her for murder and manslaughter at the same time, because they're not even consistent. They really should have picked one from the start. And you don't look sincere when you're a prosecutor when you say, she mowed him down on purpose because she was angry about, he kissed the girl in Aruba. And so she decided that night on the precipice of a snowstorm in front of all these people in the house to just mow him down and do all that. And then at the same time say, well, she didn't do that. Then, she must have been intoxicated and just been reckless. Which is it? I mean, you have to have sincerity and credibility as a prosecutor and say, this is her theory. This is what she did. And they don't have a theory to this day. I mean, they're fighting like hell to keep the murder case, which is ridiculous. I mean, because they're not going to try the murder case anyway, I don't believe. They're going to, they could win at the high court and still dismiss the murder case. And what will that say about them?
Right. Yeah, no, that's huge. And we have that on Wednesday, right? Is the 6th is them going.
Yeah, they have already, but the decision wouldn't come
at least a month, right? Usually.
And the reality is, if there's a decision that's favorable to the defense, it's probably the granting of a hearing, not a complete win, which now the trial schedule becomes an issue if that happens. Because at that point, assuming it's the same judge, although, I mean, if I were them, I'd be moving to recuse her for the hearing. I think she's a witness at a hearing, frankly. But that's for them to decide. But whether it's her or somebody else, if you do a hearing, then the trial judge would have to issue another decision, which could take a couple of weeks. And then there's potentially another round of appeals.
Oh my God. Oh Lord.
It's not believable. This could go on for months if they get a granting of a hearing in the high court.
Yeah. Okay. Absolutely. Now, I wonder though, like you're saying, Mark, doesn't it just make sense if Hank the Tank just dismissed counts 1 and 3, because after he's reviewed this evidence and he has poured into and reviewed everything, that would be the best shot I would believe that they would have is on count 2, would be the only shot in hell that the Commonwealth has.
I agree with you, but it's all scales of relativity. Their best shot to me is still a Hail Mary.
It is wicked.
3 seconds left on the clock, and it's on your own 4-yard line, down 6. To me, I mean, I don't know why he's doing this. I don't know what their thought process is. When you're a successful lawyer in private practice, I don't judge. I don't really care.
Right.
So he's a fine lawyer and he has his reasons. I just can't fathom from a credibility standpoint why you would jump into this, POS, because this is a pile of that. This is just, I don't know what he's doing.
Yeah. And Mark, this is a great question. Thank you, Grandma Suze, because this came up in the Vanity Fair article as well. But listen to me. So I had Rita on over the summer. She came on with me. And
I have a great answer for this. I'm going to make New York sound sane. You're going to love it.
Because Rita told me this, and I thought to myself, now I believe Rita. Okay, she goes, "This is how it happened, Kim." I go, oh, I don't know if that could be even correct. And then to read it in Vanity Fair that it was that Jim McDermott just held that ball and said a number, didn't show the ball to the defense is mind-blowing to me. Tell me what happens in New York.
Well, this would never come up in New York because the process from the jump is much more intelligent than the process in Massachusetts. What I can simply say is the way they do it in Massachusetts, if this is how they're going to do it, it is outrageous that the clerk and the clerk alone would have access to what's happening and you wouldn't have the parties view it. That's just makes no sense because all it's going to do is invite the conversation that's happening now. There's no confidence in the system. But in New York, it's very simple. You pick a jury and you pick alternates, and before the trial starts, who are the 12 jurors, 1 through 12, and who the four, or whatever the case may be, alternates. And you know, before opening statements, who the alternates are. You know who the jurors are. You know who the foreperson is. This is not rocket science. The way they do it in Massachusetts is just inviting conspiracy, speculation, corruption. And, look, you even saw Allen in Vanity Fair, it was a very bold statement, flat out says, this feels fixed, or words to that effect. I don't remember the exact words. But why would you ever do this in a way where the clerk has unfettered access to the information and nobody else does? This is how people felt for, basketball fans. If you remember, in 1985, when the Knicks got Patrick Ewing, everybody knew before that draft, the first draft lottery in the NBA, that this was fixed to make the Knicks get the first pick. I mean, it's just kind of a running joke in sports, and it's the same idea. If all the jurors who got booted from the pool to be deliberating jurors, if the theory is that they were going to be favorable, if you will, or seemed at least open to the defense. I'm not a statistician, but 3 out of 3 getting booted, that's troubling.
Yeah, so much. Like, and even if you did like you're saying, a statistician, it could be like less than 0.0 something percent that all 3 out of that would have been, selected at random. I also wanted to tell you that I wasn't alive for the Patrick Ewing draft, so I don't recall it.
It's only 1985. Jeez.
I was born in 86.
Wow. So you don't even remember the 86 championship. That's too bad.
I don't, but we could try to see if there's highlights and put it up on the screen someday.
Many people think that's the greatest NBA team in history, the 86 Celtics.
Listen, I think that I was there. I had been born, I'm sure, but
I got it.
Oh my gosh.
But it's also like, these jurors get booted, and then, you read this recent stuff, how, they're being doxxed or approached with this bizarre, implicit threat or quasi extortion of, you need to talk to people, or I know all these things about you. And it's, again, this case is just, you need to take 3 showers after you read all this stuff to just clean yourself from it. There's everything about this case just stinks like rotten fish.
I do. Oh gosh, yeah. It's really, it's heartbreaking, because like you're saying, at the end of the day, I think that, especially, I know for myself, I know for you, I know for so many other people, it is always just been about getting to the truth of the matter. And my belief from a medical standpoint, nothing else, take all the bullshit out. Medically speaking, Officer John O'Keefe was not sideswiped by a vehicle at 24.2 miles an hour in reverse, didn't counterclockwise rotate. I won't say pirouette, okay, but and then land from standing up at 6'2", and then going down to the ground to cause the catastrophic brain damage, which, me going over the testimony, going over Dr. Renee Stonebridge, the neuropathologist, was really important for me. Like, to see that he has, you don't bleed from hitting your head in the back, Mark. You do not get, subarachnoid hemorrhaging in your frontal lobe, in your temporal lobes. You don't have your brain stem herniate. That does not occur.
It's funny, because obviously you're medically trained and you can speak about things that to people like me, I mean, I believe everything you're saying, but it's going this way. But even on like just kind of a layperson way, car barrels into someone at 25 miles an hour in reverse, which is actually very fast for reverse. Very fast. And a large car. I mean, big car, to the point where somebody lands, 20 or 30 feet away. I don't think you have to be a medical professional or a genius to say there's got to be some serious injuries in the chest, trunk, arm, and I mean bones. I don't mean like cuts on the arm. And there's none of that. And on the opposite side of that conversation, there's got to be some serious damage to the car. And that's kind of what the ARCA guys were saying, that it was a two-pronged problem for the prosecution. The body doesn't have those injuries, but at the same token, neither does the car. Like the
Yeah.
car have damage. You don't just barrel into someone at that level and have no real damage other than, broken polycarbonate, which is another thing I didn't fully understand at the trial. I don't remember the word polycarbonate being mentioned once. And, I remember seeing even on I think it was the Dateline thing or something else, where, you could punch that taillight as hard, you might break your hand, but you're not going to break the polycarbonate, right? I mean, the whole purpose of that is to not break. I mean, there's a reason why polycarbonate is used, I think, in safety goggles, because it
Yep.
doesn't break like regular glasses would go in your eye. If you get whacked by something hard, the whole point is it's not going to shatter. Well, how the hell did the taillight shatter into 40 pieces?
Well, and it's also used in fighter jet cockpits, okay?
Right.
For speed and for its protective abilities, for its durability.
Right.
But you're telling me that Officer John O'Keefe's right upper extremity shattered it? Because I've said, is he the Terminator? Does he have titanium? That doesn't make sense.
40 something pieces scattered around. I mean, you're talking about boom, right? I mean, it doesn't make sense. And I'm not sure why we never really heard about that or heard a witness, whether a witness from Lexus or an auto body shop or somebody, just to explain, or ARCA even, I don't know, to explain what the material is and why it's used. Because here's the other thing. There's a reason why they use polycarbonate for taillights, because it doesn't shatter.
Yes.
That's the whole point. It's not out of because it looks nice. The idea is not to shatter. And if it does, I mean, obviously things can push into it, but I mean, at that point, it pushes in, which is consistent.
It wouldn't go outward. Yes. Yes.
Out the other car. That's right. About in the driveway. That's what I mean.
Yeah.
It wouldn't explode out. It would push in.
Yes, you're absolutely right. And there wouldn't be, a spontaneous combustion of a polycarbonate. It's a blend taillight that just, breaks into 45 plus pieces of taillight that we know has been discovered over a 3-week period.
Is another thing, and I expect this on cross-examination and argument at a retrial.
Mm-hmm.
Even if you believe, which I don't, even if you believe that the taillight broke into 40 something pieces from an impact going reverse in 25 miles an hour with a human arm, if they found a piece of glass the night they were searching in their CERT team and were side by side, like you see on TV, look at us doing a security sweep search, whatever you call it, and you find a piece of glass or a taillight, you already know that the vehicle is missing a lot of taillight.
Mm-hmm.
You also know it's very dark. So you don't come back the next day when it's daylight. That's impossible. You would never settle for one piece of taillight. You would never do that. You would come back in the daylight, and if it took double the amount of people, you'd bring double the amount of shovels, and you would crack it, and you would sweep, and you would say, if this is where you found the one piece, that's where we're going to refocus the search in daylight and do it again and again. And they never did it. And then if that's not bad enough, when the next piece, revealed itself, or whatever the words were, whether it was Berkowitz or Buchanan or Proctor or whatever, one of these three guys found another piece, it's the same level of analysis. We just found a piece of taillight, and their attitude is, okay, take it and go to work. No, at that point you would say, send the team, we've got evidence, and you would get it the first day. And this is the same it's like Groundhog Day again and again over the course of 2 weeks. There isn't any police agency in America, not even the Massachusetts State Police, if they're telling the truth, that would do it in that way. There's just no way. And again, it's a murder case you're building for, or at that time, a manslaughter case, whatever, against someone who you accuse of killing a well-regarded police officer. It doesn't, it makes no sense. Even if you accept them, like, you know, what they're telling you, it just, a 10-year-old would say, that doesn't make any sense.
Yeah. And you know, Mark, I always just had thought too, I had been reached out by some plow drivers, right, that just do that. And they said to me, which I was like, oh my God, you geniuses. They would say, Kim, if this shattered while on the road, because Karen Read was never alleged to be on the grass, correct? She didn't veer off the road. The shattering would have occurred, and the pieces, the shards of the polycarbonate would have been on the ground, the road, pavement. Lucky Loughran plowed. It strains credulity to think that when somebody is plowing, and I learned because of Mr. Trotta telling me from the Department of Public Works in Canton that you do the middle of the road and then you do the end, and you like middle of the road pass, and then finally you are doing the sides. For them never to find any pieces of taillight at, you know, God forgive me, but the Asian couple's home or further up the road, it would have never been in that yard. And that is it. It would have been moved up because of a weather event.
How do they explain the glass on the taillight that doesn't match the glass that John O'Keefe?
I don't know.
That's a similar problem to the planted taillight theory, because what possible explanation could there be for a different glass to be on the, you know, resting on the bumper, not the taillight?
Right? Yeah. Yeah. I mean, listen, you and I, we know so, you know, so much. And so do our best friends from out of town. They know everything, you know, too, about the case. But these are just the things that are the things that make you go, that we're just, you know, it just gets brought up when you start going down one thing. I mean, and like exactly. And you've always said, Mark, and I always would believe if there was coincidences, there are coincidences. I cannot get behind that there is 19 different, you know, specific instances that are going on around about the same time. Too many questions, the Canton Triangle. And I just can't say, okay, I'm going to continue to just close my eyes and pretend and look the other way.
There is a reason why, if the Vanity Fair report is true, that they couldn't get a single person in the DA's office to retry the case. I mean, in theory, they would know more about this than we would. They know, you know, how the sausage was made in the investigation. And to a man and woman, they've all said, not me. I don't want to be the one who gets ruined over this. And nevertheless, you know, to go back to what we talked about, you have a DA who says, well, I don't like what you're telling me, so I'm going to find someone else. And I'm going to keep going until I find someone who does. And this is clearly a DA's office in crisis. I mean, that is, I don't know a single person in that office, frankly, but I can't imagine what's going on in there and the utter lack of confidence in the leadership in that office. If everyone is saying this is not the right case for me to a man and woman, and the DA says, well, fine, I'll pay someone else more money to do it, and we'll just go from there. I don't know how, you know, they even got this far after they got all the materials from the federal government to at least not take a deep breath, take a pause, reevaluate, re-interview. Apparently they didn't. So, I mean, I don't know how the issue that happened with the inverted video, I don't know how that even possibly could happen. Okay. Let alone in any case, let alone at the time, something that was the biggest murder case in the country, that they could do this. So I don't, that office is in crisis. As far as the question on the screen, who is Attorney Jaffis? I have no idea what we're talking about.
Okay, I have to tell you about this one. So I posted about it. Court TV, after the Karen Read, after the Vanity Fair came out, Matt Johnson, who is wonderful, from Court TV, went over what the civil suit that was in favor of Karen, and they had a attorney named Big Case Mike Jaffa, and he got on, and I wanted to go down this path with you, Mark, because this attorney's comments about Karen were so egregious. He said that he hated her twice. Okay. A man that does not, an attorney, a bar, like a man who is an active attorney.
Massachusetts?
No, I think he's out of Michigan. I think he's people were saying he's like a personal injury attorney, which whatevs. But he makes frequent appearances on Court TV. And like I said, in his 4-minute clip, I can't, me, I can't work the desktop, but it is something that is unbelievable. Says, I hate Karen Read. I detest her.
Okay, right.
Yep, go ahead. I'm sorry.
Before you continue, I mean, if you have a lawyer who is being called upon to be, a TV commentator, and the first words out of his mouth are about, he's, first of all, he doesn't practice criminal law, so he probably doesn't understand the criminal case. He's not in Massachusetts or working or with any relation to the people or the case. He doesn't know Karen Read, and the first words out of a lawyer's mouth are, I hate her.
Yes.
He should literally, at that point, say, see you later. Like, you're a clown. You're not a lawyer. You're a clown. I mean, I'm sure he's a lawyer, but, that's just an attempt to be provocative and, help Big Case Mike's website. I don't know, but I don't know who he is, so I don't know what to say about him other than to go on TV, to be brought on as a commentator and start talking about how you hate her. You're a lawyer. You're supposed to be, sober, neutral, observant, call it what it is. To come out guns a-blazing that you hate her, that's just, I mean, that's a clown show. That's.
He also said, Mark, which really got me, and I said, well, now I'm gonna have to talk some shit. He then said, I hope that, because when they were talking about using the Vanity Fair article potentially in the new trial and any of the 2020 or the Dateline against her, he laughs about it and then says, I hope that she's been given enough metaphorical rope to hang herself with it. And after what Trooper Proctor said about Karen Read and literally wishing death upon a presumed innocent defendant, my stomach, I had a pit in my stomach. And listen, I have never, now I'm taking myself out. It's not that I'm pro Karen. It's not anything about that. I have never heard an attorney on national television say that they hate someone twice. I detest her. I hope she has enough metaphorical rope to hang herself with it. And and Matt Johnson was like, he's like, well, that's your opinion. And saying that she had ruined, she had come after the community. He didn't really kind of know everything he was talking about. He was saying that she just was trying to avoid getting pulled over that night for a drunk driving. I'm like, okay, dude, you don't know shit about shit.
You can't have people like that on and abuse their law degrees. But also, and I don't know who Matt Johnson is, but this is like the frustration with the media people. If you're going to bring on a lawyer like this to clown you, I mean, because let's face it, it just makes Court TV look like the clown show that it is. As a journalist, you ought to say, why do you hate her? Like, you're a lawyer. Just tell us, what makes you say that? And his answer would be, humada. I don't know. And, he would be exposed for what he is. He just wants his 3 minutes on TV, sound provocative. I mean, look, it's okay to have lawyers on who tell you in advance, my editorial slant is, I think that she comes off poorly. I have reason to believe she might have crime. But if the best he can do is say, I hate her. I hope there's enough rope for her to hang herself. And then when he gets into the facts of the case, he's not even talking about anything that makes sense. He doesn't even understand the case. At that point, you have to say, clown, goodbye. Like, this is court TV once again owning itself and exposing itself for the clown show that it is. I mean, that's embarrassing. That's worse for court TV than, big case Mike.
Yeah, it just, to me, I was so upset, not only for her, but like for women. I'm just sitting there like, oh my God, this man just hates her because she's like, what do you just hate? Did she not go out with you? With did you one time live in Massachusetts, you friggin' weirdo? But it also is just another concept of somebody having such vitriol in this case, and it is completely unwarranted for you to hate somebody, Mark. That is not not your legal argument, and that is not any sort of any commentary that makes sense on that platform, in my opinion.
You should not platform someone like that. I mean, look, they have a law degree. They're being interviewed on court TV. Most people are going to think, well, he must be somewhat skilled or distinguished. And then you hear that. And that's just a waste of airtime. I mean, that literally adds nothing to any intelligent discussion about whatever issue he ostensibly was supposed to address, as opposed to how much he hates her and hopes that she goes down. I mean, that's odd. I mean, I haven't seen it, but wow.
When you got to watch it, Mark, you got to watch the clip. It's 5 minutes. And I swear to goodness. And of course, every troll that we know was reposting and saying it's no different than anything that anybody. I go, oh, well, this is an attorney. I expect him to kind of,
no, he's on TV because he ostensibly has legal analytical skills to enlighten the viewers about what's happening and analyze it. But if all he can say is, I hate her, that adds nothing, literally nothing.
Yeah, and like you said, though, afterwards, I thought to myself, I said, oh, you dummy. He probably did do it just to be that salacious and to try to get more clicks potentially for his 300 followers on Instagram. But I digress.
I mean, I don't know who. Wow.
Yeah, no, he's nobody special at all. But oh gosh, it was just, it was very skin crawl. And I was like, dude, are you saying this crap about people who have, unalived their own children? Or is this man get on the television and say that as it's relating to, I put it as, oh gosh, who's his name? Adam Montgomery up in New Hampshire, who unalived little Harmony. Those are people that I can feel you having a passion as for, children. And I was like, at worst case scenario, in the worst light, this was allegedly an accidental, unaliving of Officer John O'Keefe. And I know that we've got the trumped up charges, but I think most people would agree that it was overcharged and it should have been only manslaughter as it was initially, how it was initially charged. And then to have this lunatic say you hate a woman because at best she is fighting for her life and she is going to be acquitted. And at worst, this was the worst night of her life. The love of her life is not here. And she made a horrible decision and drove drunk and didn't know that it happened. Allegedly. You know what I'm saying? In the worst case scenario. And that was just, it just felt so personal, and it was really off-putting.
Listen, I mean, you could probably name them all in 5 minutes. They've had some bizarre choices of lawyers and otherwise that they have chosen to platform to discuss anything related to this case. And I mean, one of the hosts on court TV, in the early stages of the trial, I'll never forget this, I didn't even know her. Do you remember during the trial when there was discussion about the one EMT who, really wanted to die on the hill of friend versus acquaintance?
Yes.
Yes. And so one of the court TV hosts had said, oh my God, this is like the dumbest thing. The defense is this. and I responded to her very professionally about, well, actually, it matters because of this, this, and this, and her response was block.
Yeah.
Julie Grant was her name.
Yeah. Julie Grant also blocked me because of her footprints in the snow theory, in which she had, I said, oh my gosh, whoever put this package together did her so dirty. They had Gallagher with the friggin' snowblower, and she's saying, why were there no footprints in the snow as he's snow blowing? I go, oh, Julie, get a life and live it, you know?
No, Court TV is really,
oh, it's hard. It's hard. Yeah.
over the year.
Oh my gosh. Yeah, no, I totally agree. So then also, Mark, can you give me your take on the ruling as it relates to the civil suit and the stay being granted, which I think most people thought would happen, for Karen having to testify, or no, I lied, be deposed, and any evidence related to her has been stayed until after the criminal trial?
Yeah, so it's a huge win for her, which we can get to in a minute. But what I don't understand is the huge discussion about it. This was the most obvious yes ruling that was going to be. That's how this works.
Yeah.
The reality is the tactic by the plaintiff's lawyer was purely that was for the press. That was for the public, attacking her for speaking, Karen Read speaking out and, weaponizing, the Fifth Amendment and all of that. And, when you're a criminal defendant, you don't weaponize your constitutional rights just for what you may not like the public speaking, but for a lawyer to accuse somebody charged with murder for weaponizing her, basically God-given constitutional right to remain silent, which applies in a court of law and official questioning and all of that. That's not weaponizing. That's asserting a fundamental constitutional right. Big difference. But I don't fault them for making the motion and making the argument. Well, if you're willing to talk all these times, why can't you talk to us? But that's just not how it works. So this was always going to be the ruling. I mean, I don't know why anybody seriously would have thought that a judge was going to say that somebody who enjoys a Fifth Amendment right not to, incriminate themselves can be forced to, assert that right in a deposition and be grilled before that trial is resolved. And, in theory, it could be used against her, all that kind of stuff. So the fact that the judge said, I'm going to stay her from having to give a deposition is, my response was, duh. I mean, that's not anything. The fact that the rest of the discovery moves forward, I mean, that's just the icing on the cake for them. So they can continue to press ahead, gather as much as they can from the plaintiff's side, which of course, the key witnesses are going to be all the people at the bar who said Karen Read was, as sober as everyone else there, that sort of thing. And they can ask all the usual, Alberts and McCabe's that were out that night, all the difficult questions. So I think the ruling was exactly as you would expect, but notwithstanding that's a very good ruling for her. I don't understand the civil lawsuit. I don't understand how they expect to do it. And if the O'Keefes are aligned with the Alberts and whatever, and whether they are or they aren't, I don't really care. I don't know. But for those who think they are, they're not doing them any favors. Because they have all testified in a way which will be harmful to the plaintiff's lawsuit.
Okay, and Mark, will they be able to depose? So for the plaintiff's side, they'll be able to continue with their depositions moving forward. It was only regarding Karen that the stay is in action, correct?
Yeah, because she has a Fifth Amendment right, not to incriminate herself. And that's broadly interpreted. That doesn't mean, oh my God, she's admitting she's going to incriminate herself. That's not how it works. So yeah, I mean, she will be free from doing that. They could certainly, from the plaintiff's side, try to, schedule depositions during the discovery phase for other people. But I mean, what is that going to do? Their theory is Karen Read was drunk and this and that. I mean, who are they deposing that's going to have any harm really on her case?
And it wouldn't be, it's not available for it's not available for like Karen to depose, though, anyone that was out that night at this time, during this time, that couldn't go on, correct?
No, the defense can depose Brian Albert, Chris Albert, Brian Higgins, Colin Albert. Yeah, no, this is a disastrous ruling for the plaintiff.
Okay. Very interesting, because there has been Twitter lawyers that said that is not how this works, and that Karen would not be able to depose those witnesses who we've already heard from at criminal trial.
Well, I read the ruling for 2 minutes because I've been, very involved
Busy,
in other things for the last 2 weeks. But I did see it, and I think what I read was that very specifically they stayed a deposition of her,
yes,
but did not stay anything else in the litigation.
Correct.
Well, then once again, if you get a law degree from Twitter, it's worth, whatever. But I wouldn't rely on it. That's all. But
Oh my gosh, I know, you're absolutely right. Okay, let's do questions. Guys, if you have any questions, ask Mr. Bederow. I'm going to go through these super chats, and then we'll ask a couple questions. And then I know that he has been so good to us. We appreciate him. U.S. citizens, good U.S. citizen says, yes. We need you to. Thank you. Oh my gosh, I love your pink duck, Lovey. And Loveromi with Cheese says, I'm so happy to spend my Sunday evening with my favorite grifters. Grifting ain't easy, babe. I had to pay $12, Mr. Bederow, for that Vanity Fair subscription, but we've got a whole year, so don't worry. Anything else that comes up, we'll get together. Tess says to us, Mark, are there more letters? You are fantastic.
We'll have to wait and see.
Maddie Wag says, is there a chance that Hank the Tank, I make it up as I go, digs deeper into the case and that he'll say, I can't do this because she is clearly innocent? Mr. Bederow.
You'd like to think so, but in his original statement saying, I'm going to follow wherever it goes and do the right thing, it sounds like the right thing to say. But if you've been looking at the filings in support of subpoenas and other things that they've been filing in the last several weeks, he's using very aggressive, some would even say obnoxious language, making conclusory statements about her guilt, what she did. And that's not the way that somebody who is open-minded writes. So
sorry,
I don't know, again, why he's motivated to do what he's doing, but he's been around a long time. He's a real lawyer. He's a skilled lawyer. If he's writing his motions in the way that he is, with these conclusory statements of how guilty she is and how she mowed him down and did this, he's telegraphing what he's doing, which is attempting to convict her of a crime. So no, I don't think at this point that he is anything other than doing a second trial.
Yes, absolutely. And Loveromi with Cheese, she said that, I've said this from the beginning, nobody in the Norfolk DA office wants to touch this case, in my opinion. That's why Lally had nobody else helping with direct and cross. Interesting, even though we did have Laura McLaughlin, his helper, who made one argument in front of Bev. Morrissey is POS, I'd like to say. He's a POS committed to this BS case. And we agree 100% with that, right?
I won't use the language, but yeah.
No, I think just kidding.
The case is a dog. It's a loser. It's terrible judgment. He had a chance to reboot it when all the materials from the feds came out, and he continues to do this. He had another chance after the first trial. He continues to do this. His own office is basically, in a mutiny phase against him on this case, that he has to go outside the office. So, if you live in Norfolk County, if you think this is a best practice in running a DA's office and you want to vote for him again, then, you deserve what you get. because the place is in crisis. Look at it. Look at. I mean, all these state troopers who got punished, they're all embedded in the Norfolk DA's office. They all, or most of them, give money to Morrissey. I mean, it's just one big cesspool of bad and
incestual almost. It just does not stop.
It is, and you should fumigate is the word I'm using for. And if you have no confidence in the office, then you deal with the guy who's in charge of it, and you vote him out or you keep him. I mean, he has every right to run, and if he wins, he wins.
Right. Yeah, absolutely. Nothing changes if nothing changes, everyone. Okay. And True Crime Junkie, the OG, thank you so much for becoming a member, Lovey. Oh, I lied. Joseph Kane, thank you for gifting a Nurse Kim membership. Then we have Lovely said, question, Officer John O'Keefe had DNA on him from not identified people. Who are they? Can they or have they already test the DNA and prove if they match from any of the McAlberts? P.S. I love your show. Lovey, lovely. They did go for it.
The understanding, if I recall correctly, is that there was an insufficient concentration of other people's DNAs in what they call a mixture. And a mixture is just a pile of DNA of multiple people, whether it's blood or whatever. And they try to, separate out as best they can. And in the DNA mixture, what they call majority contributor obviously was John O'Keefe. I mean, the blood is going to be mostly his, and they were unable to get a sufficient concentration of the other contributors. And if that's the case, then it becomes very hard to get a court order to get someone's DNA, because the Fourth Amendment protects people. The more intrusive a search is, the more protection you get. And when somebody says, I want to either get a warrant or an application to take your genetic material literally against their will from your body, and I'm talking about Colin Albert, Brian Higgins, those types, courts are going to be very hesitant to do that. And when there is an insufficient sample to compare it to, a court is going to say, well, then even if I give this to you, you're never going to be able to make a match. It's too intrusive. So unless they are able to somehow get an opinion that they can determine that there's a sufficient sample for comparison, then I assume they won't get the samples. If they do, then I would think they'd be running to court within 24 hours to try to get samples from the people she's talking about.
Yeah, and absolutely. And I remember that it was, I think in certain areas, there was up to 5 contributors. That was the most. I know there was 3 on some parts. And then, and I think the back of the hoodie, for whatever reason, I feel like there was actually more than 1 contributor. And I thought that was very interesting. God forbid had somebody come up from behind. And then Lover with Cheese said they're just angry twit idiots who claim everything is against the law. It's honestly embarrassing to see.
The bad legal take of the century, not the day, not the week, not the month, not the year, not the decade of the century came out this week, which was, Vanity Fair, because they, said that the search might have been at 227, even though they hired their own expert. They're subject
opinions, yes,
and they're subject to defamation because they accuse the state police of lying. Isn't that amazing? That came from the couch. That came from the couch in Indiana.
Oh gosh, it doesn't end. It never ends. Sometimes she watches. So hello, if you're watching, nice to see ya.
It is what it is. But Vanity Fair will not be getting sued
at all.
I assure you.
And also, it is not against the law. Also, Mark, can you let everybody know that anytime that if you believe that the Mass State Police are lying, that we are allowed to say, I believe that the Mass State Police are lying.
So there is this little thing in the law. You Perhaps you've heard of it. It's called the First Amendment to the United States Constitution. And there's actually a reason why it's actually the first in the Bill of Rights. Number one, which is freedom of speech, freedom of expression, and whatnot, that the government, with very limited exceptions, obviously, has no right to, criminalize or make illegal your right to free expression. So if it's your opinion that there are people in the Massachusetts State Police who have lied, you are certainly free, as am I, and I have expressed that opinion before, to say, I believe they lied, okay? Like you and others, I believe Michael Proctor lied at trial. That's my opinion. I think there's a lot of evidence to support that opinion.
Mm-hmm.
I wrote in a letter that was filed in another case that it is my view, and that there may be evidence in the prosecution's possession, that a sergeant lied about the true and accurate condition of a video that was presented at trial. That's my opinion. I'm not getting sued for that either.
Nope.
Okay. We could go on and on. You have a right to have an opinion about law enforcement. This is not an Orwellian novel, okay? This is not, as I said in the tweet to this person, this is not the Soviet Union under Joseph Stalin, or China under Mao. You can speak your mind, okay? If you think the police are lying, you could go get a bullhorn and stand on the public corner and scream it for 10 hours a day. You should see what happens, what people say to the NYPD on a daily basis.
Yes.
Okay, every day. You don't have to agree with it. It can be shameful, but they have a right to do it. And so the First Amendment will protect you from accusing, if it's your opinion, that the Mass State Police are lying. The same way it protects Vanity Fair from reporting that there's a strong reason to believe that a search happened at 2:27 a.m. because we got an independent expert who told us that. There will never be a lawyer who's going to say that Vanity Fair made that statement with no regard for the truth in a reckless manner or anything close to that. It's just ludicrous.
Yeah. And you know what? Also, for my freedom of expression, I have to one time, just for the nurse Kim loveys. On your mark, get set, punch a Proctor. Okay. Cheyenne Brown says to us, we had the dash cam and no one ever got into a police car. We watched it recently on someone's show. That's very true too.
Are we talking about the dash cam from McCabe and Karen allegedly praying, or what are we talking
allegedly going even into that car? Well,
I would have thought, because I remember reading that report, I would have thought that would have been an issue in the first trial. By my recollection, that was never mentioned. I would assume it would be a very large issue in the second trial, certainly as it relates to this debate over a search.
Nice. Well, thank you. Yeah. Yeah, you know what? That is so true. That is really, really a great point, Cheyenne Brown. I will look into that too. Ryan F., first and foremost, Ryan F. has a doggy. This doggy right here, my allegedly best four-legged friend from out of town, because Kino is my first best friend. My second best friend is this doggy who went as me for Halloween this year. Okay? Stop it immediately. I do have a picture. I'm going to be posting it. A Nurse Kim costume on this little beautiful blonde. Okay? Reminds me it could be my child. Anywho, Ryan F. says to me, did Plevin break any laws by contacting the juror last week? What if the juror's name was impounded? Ethically, this seems like like actual intimidation, but the law and ethics like to play opposites in mass. Do you have any comment on that?
As far as the name being impounded, you have to start with this principle. A court order, warning people of doing things or not doing things only applies and impacts people who are subject to the jurisdiction of the court and the court order. So I'm not saying it's right or wrong what he did. It was pretty sleazy. We'll get into that in a minute. But the fact that an independent third party not subject to a court order did something that the order apparently, forbids, can't be punished for contempt or anything like that for violating a court order. I mean, I'm not going to literally opine on whether it broke the law. It could certainly be interpreted by some as a form of implicit extortion. It could certainly, if you assume that there was some sort of federal jurisdiction, which off the top of my head, I'm not analyzing this, but all would be advised to look up, what is it, 18 USC 875
Yeah.
about, communications that are, threatening, harassing, and whatnot. Addressing a juror by her name. To me, if anything, it's more funny than anything. And what I mean, it's not funny to talk to a juror like that. But the first paragraph saying, you may have heard of my show, you may know who I am. I don't bet, but if I did, I would bet the farm there's no way in hell this person ever heard of that guy. Okay.
No. But it was just upsetting to see so he kind of put out the first email, but there was subsequent, so that was where it got a little icky. If he had done the first one, I would say, hey, shit happens, guys. Who cares?
And there are allegations of misconduct. And of course, I say again, you're getting into the very close area of implicit extortion. The obvious implication being, I know things about you. I know you've done wrong. And, I'm writing a book again.
I'm going to publish it anyway.
I'm sure it's a self-published, do-it-yourself kit on Amazon. Nobody's publishing that guy's book.
He has a deadline. He's got to get in.
No, it was interesting. Some of the language speaking in the possessive, like we have a trial. That was weird. So again, I don't, I haven't studied it enough to really go over the illegality of it.
Yeah.
But it's problematic. It is sleazy. It's clear what was happening. And of course, the real questions are, how do you get that information and where do you come up with all this stuff about, what the juror was allegedly doing? But, it's for somebody else to decide whether it's illegal or not. But it is, it's not surprising. Let's just put it that way.
Yeah. And thank you, Deidre Sargent, for becoming a new member, Lovey. And then we have Loudmouse, who I'm obsessed with. You made me cry the other day with that beautiful comment and Bible verse, Lovey. I love your picture, too, and your earphones. She says, I watched multiple sources of media on both sides before I made my opinions public. I did, and so did Vanity Fair. Turtle Boy isn't everyone's cup of tea, but strictly holds himself accountable with receipts. Yes, Loudmouse, I love that. And I love everyone who took the time to read court filings, to view evidence as in totality, to listen to testimony from the first trial, and to come to your own educated conclusions. I'm not here to make anybody change their mind or to try to pressure anybody or to try to round up troops. I just am going over information that I, would like to with people who would like to watch it with me. That is it. And I respect anybody who does not agree with me. But if you are going to come at me in a wild way, I'm going to also defend myself, right? And I think that we all have that opportunity to, my opinion is just as valid as, A, B, and C on Twitter or any other platform. I've reviewed what I have reviewed and have come to this conclusion independently without Turtle Boy whatsoever in my brain. If there was anything that concretely or medically added up for the Commonwealth, I would be reporting on that as well. Mark, any words?
Look, I mean, if you're a journalist, you need receipts. That's true. And people, no, I understand, but the point is why people get angry over differing opinions. I don't get it. Again, doing this 26 years, I've never seen anything like this. It's mostly keyboard warriors hiding behind Twitter or screaming outside, for their own motives and reasons. I think a lot of the people screaming and yelling spend their lives looking for drama, living on Twitter, tend to be miserable people, very few real relationships. It's all internet based. There's just so
Right.
much unhealthy nastiness, looking to, get over on people online. It's all personal attacks about, how
Ugh.
people look and this. It's all, I don't understand any of it, and I've never seen anything like it. But part of the problem too comes down to they seem to have a misconception again on how a criminal trial works. A criminal trial is to determine whether a defendant is guilty or not beyond a reasonable doubt. And that's the only issue that happens at a trial. And you can scream and yell back and forth, she did it, she didn't do it. But at the end of the day, that's the only issue to be decided. And these people don't get a right to claim a monopoly on the concept that there is no justice if the jury doesn't convict her of whatever we say she's guilty of. And they just want to skip straight to sentencing and pronounce her guilty and challenge you, me, anyone else who says, well, wait a minute, the evidence doesn't seem to support that. Let's wait and see. And then when you talk about, I want justice for, a good man as well, you can't be serious because you disagree with me. And this is just a fundamental misconception of 99% of the people from, who act the way they do. And I'm waiting for a sane discussion with someone, preferably a lawyer, just because they understand the concept, to have a, sophisticated discussion, why they think the evidence supports what it does without the personal stuff, without getting silly and nasty. And
I would love Krowski to do with you. I would live for a Krowski and Bederow because
absolutely. I mean, look, I've been asked before, by the idiot in the attic, and no way, you're a clown. I would not, with all due respect, you're meaningless to me. I'm just a drunk in a bar anyway. But, a serious person who does this for a living, I think I'd mentioned months ago, Reddington or Krowski. Lawyers respect lawyers. Look, the fact that they had, dogs in the race at some point, representing people that I think a lot of people who listen to you don't like, that doesn't bother me in the least. But they're lawyers representing clients, and that's what we do. And that doesn't impact me. But I'd be much more interested in hearing people like that than just people who scream and yell and live on, Twitter all day and have, again, like some of them anyway, just no seeming personal life. Somebody mentioned Wendy Murphy. I would not platform Wendy Murphy. She is, to me, not a lawyer. The other two, absolutely.
Well, and I just think that it would be so valuable for us, right? For us who are not lawyers to hear, because let's bring, I know that there are cries for civility on the other side, and yet then they are doxing children and they are attacking anybody that they choose at any given time that is not trying to, nobody wants to box all the time. Okay. And it is just a consistent battle at every post, at all turns. I don't want to do it, but I would have, and I have sent, and Mr. Krowski sends, he's wonderful. He'll post on my stuff. And then I respectfully speak back to him, even though I don't agree with him. I do agree with his expertise and his knowledge in the field as a criminal defense lawyer.
He's a highly respected lawyer, and so is Reddington. It's fine. We don't have to all agree or have clients with the same interest to respect each other as lawyers.
Yes.
And maybe some of the, Twitter yahoos could try that same concept.
Maybe. And a Southern mom asks us, is there a way that any evidence related to Chloe could be obtained and used? Or is it a better strategy to just call out all of the reasonable doubt?
Well, Chloe is part of reasonable doubt. Again, if the jurors are willing to say that the injuries on John O'Keefe are reasonably possibly from a dog bite or scratch, as opposed to a car getting hit, then she's not guilty.
Yeah.
The dog could theoretically wipe it all out. So I think when people say, oh, they need to get rid of the third party culprit or do this, it's all part of reasonable doubt. I think the issue is how you marshal the argument a little differently, but I mean, you're not abandoning anything, but I mean, I think they also got stonewalled on the dog thing. I mean, this whole thing about, well, the dog was sent to Vermont and we don't know where, and they were misled about a bite history, and they were not given information of where the dog was. That's outrageous. I mean, the judge absolutely should not have cut them off from discovering more about the dog. So no, I would think the dog will be a part of the second trial for sure, because listen, any juror who has a dog, getting rid of a dog, you know this. I mean, I've got one of my, well, where'd she go? She was here a minute ago. Oh, she's on the floor. One of them. I have 2 dogs. They're like kids.
Family, our actual family members.
What it would take for me to just get rid of a dog voluntarily, it could never happen. Now, if you said, oh my God, but they're biting people. When you watch the testimony of Brian and Nicole Albert about the dog leaving, they're talking about widgets. In fact, they kept saying the dog, not Chloe, the dog. Nobody calls their own dog the dog, not really. So I think it is actually a big deal. And I think that jurors who own a dog would say, that's weird. Weird. That you would fight like hell. What can we do? Get training. I want to do this. And then again, you have to marshal other facts. Well, they got rid of Chloe and then they sold the house. They did this, they did that. He retired from the police department. He moved. I mean, there's all kinds of stuff that all happened in a relatively short period of time after this happened, that you would say another thing when you put it all together and you marshal it. Does that support something going on here?
Right. Yeah, agreed. And Cynthia Lynch, thank you so much for your super sticker. Jim Jerry Gunn, thank you for your super sticker. One of my 2 boys that was here. We are just one. Thank you so much. It says, attention people power. Join us Wednesday, November 13th from 2 to 5, Norfolk DA office at 45 Charlotte Road in Canton for a collaborative standout for Free Karen Read, Justice for Sandra Birchmore, and Justice for Justin Root. Stronger together, just one. Oh, that's lovely. Thank you so much. And everybody put that in your calendars if you can make it. And Pierre says, my mama told me hate is a very strong word. Absolutely. And Love a Romy with Cheese says, thank you, Mr. Mark Bederow, as always. And Cynthia, 1880, thank you for the super sticker, love. And Jen Lee says, is there any motion the defense can file to get Judge Bev removed? A writ of prohibition, rather. Sorry.
I don't know. Don't forget, they tried once on the relationship. If the case gets sent back from the SJC, it wouldn't shock me if they try to make her a witness, which could be a strong basis to say, obviously, you can't be a witness and be a judge at the same time. I'd also be curious to know if they try to make any issue about not seeing how the alternates were selected. I don't know that would go anywhere, but that whole process also struck me as very improper, although, they do it their own way there. So I don't know what they're going to do, but, I know there was discussion where we all thought she was not going to be presiding, but is. And I mean, look, what real lawyers do, they worry about what they can control and don't worry about what they can't. She's the judge. It appears that that's likely to be the case. They know what they're getting. They'll try their case. And, she's got top shelf lawyers. So they're not going to lose because, Judge Cannone is the judge.
Agreed. Totally agreed. And Emily Suaro said, is it true that they can't mention the first trial or let the jurors know about it in the second trial? How do they bring up past testimony?
There's a legal answer and a practical answer. No, there's not going to be literal discussion about at the first trial. You can't say that. Having said that, every single juror is going to know this is a retrial. It's impossible that somebody on Norfolk County, this jury, doesn't know that. It's just literally impossible. So they all know. So, but there is prior testimony. There's all other things going on. It can't be ignored. So you'll get more of kind of what you heard in the first case about the federal situation, another proceeding.
At a previous proceeding. Yes, exactly.
Previously say this, related to this matter.
Yes.
It's all semantics and whatever, but in a practical sense, every juror will know that this is take two.
Yes. Oh, great. And then Loudmouse again says that thank you so much, Lovey, says the jury needs to see evidence and videos on how sturdy polycarbonate is under pressure, speed, heat, what they hit, etc. Basic to most, but apparently the obvious isn't apparent to everyone. Loudmouse, incredible.
I don't know if it's obvious to everyone that taillights are made of super strong plastic that is designed. I don't know.
It wasn't brought up at all.
It wasn't brought up, and I would think that would factor into the physics guys, the ARCA guys talking about. I don't know why they didn't bring it up. Who's to say? I would think it would come up at the second trial, because I feel like on one of these TV shows that we watched, they were, didn't they do a little experiment where when Alan was playing with the taillight, saying you can't.
Yes, it was in Dayline, absolutely.
You need, not him, obviously, because he's a lawyer on the case, but somebody needs to do that in front of a jury. Visuals are very powerful.
We need visual aids on so many, it needs to be that, definitely. I think that there needs to be, in my humble opinion.
You need an expert to say what polycarbonate is and what degree of force and this and that does it take, how is it designed to break, and what does it mean to shatter, and why doesn't it shatter, and and why are these lights put on these kind of vehicles? And the reason is because they try to reduce shattering, and that's why they're on safety goggles. That's why they're on, as you said, like military windshields.
Yes,
that was a missed opportunity, but it won't be missed again.
Exactly. It won't be missed again. And that's the thing, guys, is that if nothing else that we can opine from this is just saying we know where things need to be a little bit more beefed up. But remember, Karen was on trying to keep this at bay, trying to keep this monster of cost at bay on a shoestring as she could. And flying out Alan Jackson, another hilarious moment, I thought, of a candor, came in the form of, you try feeding Alan Jackson McDonald's, okay? And I just said, and then I was like, oh my gosh, I'm just picturing him eating all of them sitting right at a little table eating a cheeseburger bundle. I laughed. Sorry, it's not funny.
It's not the cheeseburger, it's McDonald's. I'm sure if she tried to feed him In-N-Out Burger in California, he would gladly take that for part of the deal, but we don't have that out here. So,
of course. And then Ryan F just said, and this is Gracie, the dog, this little blonde, beautiful, who went as me, Ryan F's dog, Gracie. She will go as a Bederow letter next year. All right, Mr. Bederow, listen to me. You are the best that ever lived. You are our best friend from out of town, our favorite lawyer, and such a pleasure to always be able to just talk to you, to collectively pull our shit together and say that, we know what we know, guys. Stay in the game, if you will. I know that there is a lot of outside noise. Push the outside noise away as much as you can. Keep your eye on the ball. Keep focusing on what are, any kind of maybe filings that are coming up. On Wednesday, we have arguments at the SJC. That'll be very interesting. And Mr. Bederow, do you have any parting words?
No, although I think I'm going to be in town on Wednesday. Maybe I should go to that.
Yes.
Yeah, well, I'm not. I doubt it. As far as what you just said, yeah, these cases are won in a courtroom with juries and burdens of proof, not on Twitter. And so I wouldn't get too high or too low because people are ranting and raving and screaming on Twitter about someone is guilty this and that. And again, to go back to one of the things I said on Twitter the other day, it's not about whether she did it in a legal sense. And they're all screaming and yelling. I would ignore anyone who's screaming and yelling, she's guilty, she's guilty, she's guilty, she did it, oh my God, until, or I should say, unless and until a sober conversation, they can say, answer the question, how are you getting past reasonable doubt and these facts, and list them all, and then see what they say. And if you're having a real debate about it, now you're having an intelligent legal
Wonderful.
discussion. But you're not having an intelligent discussion with somebody says, she did it. And then why'd she do it? Because she did it. Because I said so. Because like the guy, Big Case Mike said, you know, I hate her. She did it.
I hate her. Yes.
None of that matters. And it's all about reasonable doubt. And if they're not going to engage and address those points, and it doesn't matter what, you know, people on the couch in the Midwest or people in the attic rant and rave about key cycles and this and that and connecting the Wi-Fi routers, all fair, all worth discussing. But until you wipe out all the stuff that we were talking about and all these other points and other things, Jennifer McCabe's credibility, for example, you could go on and on. That's having an intelligent discussion. If they're not going to get into that discussion about how they get over proof beyond a reasonable doubt, then what they really ought to just say is, you know what? I think she did it, but I recognize she's not going to get convicted. That's a fair position. Okay. But screaming and yelling that she's going down because I'm angry and I say so, and you're just a grifting lawyer is, I mean, you're talking to morons. It just don't, it's not worth it.
Absolutely. And I agree. And all of us, like, you know, just save yourself the trouble, right? And like Mr. Bederow just said to us, if we could have wonderful conversations and could be able to engage, that is what we want to do. We always want to encourage. I don't need to have everyone who has the same opinion as me ever. That's actually not interesting. That's not mentally and intellectually stimulating for us to only be in an echo chamber of our own voices. However, you know, don't get lost in the sauce. And there's a lot of sauce that is very unhealthy to be partaking in. And with that being said, you are an angel. You are my friend. Thank you so much for joining me tonight, Mr. Bederow, and I'll talk to you soon.
Take care. Bye.
Bye. Oh, loveys, we did it. We did it. I hope that was good for our Sunday night, just a talk, just a little bit of a, you know, a little catch up because we missed him. Where the hell have you been? Okay. I know that he hasn't been answering his FaceTimes because he's very, very busy, but I love you faces and I will talk to you soon. All right. Bye guys. Good night.